Well, good afternoon, everyone. My name is Natalie Higgins, and I'm General Counsel here at the Equipment Dealers Association. Thank you to everyone who's joining us for our February 2017 webinar. Before we get started, I'd like to just run through some basic housekeeping. This and other webinars are free services of the Equipment Dealers Association to our dealer members. The Equipment Dealers Association serves its members by advocating in Washington, D.C. and Ottawa, and by providing industry relations services such as contract reviews. Here at EDA, we don't charge extra for things like webinar, but we are funded by dealer dues. So if you haven't done so already this year, we'd encourage you to renew your EDA membership and help ensure that EDA can continue to provide these valuable services to your dealership. For today's webinar, we will take breaks to respond to dealer questions. As we go through the slides, feel free to type in your questions and we will review them. We'll either answer them live on question breaks, or if it's a very specific question, we may just choose to respond to that question via message or follow up with you after the webinar. We're also going to be conducting a couple of polls along the way, so we'd encourage you to answer those polls when they appear and to participate. Finally, for your reference, the slides, the webinar, as well as the recording will be emailed to you later today. Feel free to share that with others within your dealership who might benefit from this information. And that information will also be available through our website, which is news.equipmentdealer.org. So let me go ahead and introduce my co-counsel today, which is Mike Cass and Jeremy Renner. Mike and Jeremy are attorneys at Armstrong Teasdale, a law firm with locations all over the United States. They are based in St. Louis, but they have clients all over the U.S. Mike and Jeremy's practice focuses heavily on employment matter counseling and litigation of employment-related disputes on behalf of employers of all sizes. Mike and Jeremy have contributed some tremendous content to EDA's compensation and benefits survey, which is going to be released very soon. The resources that they've provided are designed as a starting point for dealers to evaluate compliance with applicable local, state, federal employment laws, and we're very happy to have them here today leading us through the basics of employment law in your dealership. So if you don't have employment counsel at your dealership, you really should. I can't emphasize that enough. If you wait to think about what defenses your dealership might have to an employment-related matter, whether it be a charge of discrimination from the EEOC or a wage hour lawsuit, quite simply, you're too late. Dealerships need to be proactive in order to stay in compliance, and in order to stand a chance in the event that a lawsuit is filed. And so again, if you don't have employment counsel at your dealership, I encourage you to reach out to Mike and Jeremy after the webinar to see how their services can help you be proactive at your dealership and give your dealership the very best shot it has at mitigating those risks. Mike and Jeremy do have discounted rates for EDA members, and they can provide you with more information about that if you reach out to them directly. For EDA members, I'd also like to remind you that you do have access to the EDA legal hotline, which is also available. But if you do have follow-up questions, we'll have contact information at the bottom of the slide. And without further ado, I'll go ahead and turn it over to Mike and Jeremy for their presentation.
Well, good morning or good afternoon, everyone, depending on where you are. This is Jeremy Brenner, and on behalf of my colleague, Michael Cass, we're very honored to be with you today, and we appreciate the opportunity. Hopefully, you all find this informative and interesting, and we'll be able to answer any questions that you may have throughout the program. Please do let us know if you have questions, and we'll try and take appropriate pauses to make sure that we address any questions that you do have. On your screen right now is a brief agenda of what we hope to cover today. There is a lot of information. We have a lot of slides. We won't cover them all necessarily in detail, but I understand that you'll receive copies of the slides after the program, so you'll be able to review the information more thoroughly at your pleasure. Without further delay, we're going to go ahead and go right into an introduction on employment discrimination. Hopefully this introduction is really just a refresher of things that everyone already knows. On the screen right now is a list of the what we typically call protected classes or protected statuses, and federal and state law prohibits discrimination and harassment based on these items. Classic examples are race, religion, gender, age, the things that, and disability, things that you hear about on a day-to-day basis. Some lesser known ones are marital status, national origin and genetic information, not quite as commonly known, but also equally protected. The most important thing that I want everyone to take away from this slide and really from this portion of the presentation is to dispel a misnomer that I hear with some frequency, which is that not everyone is protected by the law. So there is a common misconception that you have to be a racial minority, or you have to be a religious minority, or you have to be disabled, or you have to be old to be protected from discrimination under the law. But that cannot be further from the truth. The fact of the matter is, every employee in your business is protected from discrimination by state and or federal law. If an employer makes a decision that materially affects an employee's employment status based on any of the factors that are on your screen, their rights have been violated, or some other employee's rights have been violated. So I cannot stress enough, the most important lesson is that you cannot make employment decisions based on any protected status. That's the bottom line. The next several slides, which I won't cover in detail, give you a basic primer on federal statutes that cover employment discrimination. These are the federal laws that establish the protected classes that I was just discussing, and we're on the first slide. Hopefully they're all familiar to you. Most of them have now become part of the common American vernacular, but we did want to include some basic information about these laws so that you know what the underpinning is of the protected statuses that we were just discussing. A hot button issue is pregnancy under the law, so I did want to touch on that for a moment because this is an area where a lot of employers do go off the rails. I have heard specifically from the director of the EEOC's office in our region in St. Louis that pregnancy discrimination is one of the top 2 focuses for the EEOC. So it is on the minds of the administrative agency that has the responsibility for enforcing Title VII of the Civil Rights Act of 1964. So I want to make sure that everybody thinks about pregnancy discrimination in how they deal with pregnant employees or applicants in their business. The most important things to understand is that there are protections for workers who are pregnant, who have had children recently and have medical conditions related to either one. There is a Pregnancy Discrimination Act, and pregnancy also is in some instances covered by the Americans with Disabilities Act. So pregnant workers in your business have rights. The most important thing about the Pregnancy Discrimination Act, sorry for the technical difficulty there, is that pregnant employees in the business have to be treated like every other employee in the business. We can't segregate and treat differently employees for the mere fact that they were pregnant. So here's a classic example that I like to use. If you have an employee who is injured in a car accident and needs some sort of an accommodation based on that injury, but perhaps that employee doesn't qualify for FMLA leave or may not have accrued paid time off to use based on that absence. If you would accommodate that car accident injured employee, you must also offer that accommodation to a pregnant employee. We cannot treat the pregnant employee less differently, let's put it that way. We cannot offer less accommodations just because the individual is pregnant and didn't get injured in a car accident. So what you would do for one, you must do for the others. And it's really important that you be consistent. And you'll hear that from us throughout the presentation today. In dealing with employees, consistency is of the utmost importance. That is how you primarily avoid the appearance of discrimination. So be consistent with pregnant workers and the other workers in your business, and you will not run afoul of the Pregnancy Discrimination Act. There's a question slide here. Should we pause for questions or keep going?
We don't have any questions.
No questions pending. Okay, so we'll go right into hiring practices and interviewing and background checks. So we're going to talk now about a little bit about best practices in bringing people into the business at the beginning of the relationship. The most important thing that employers need to understand about interviewing applicants is that the interview has to be designed to elicit information that's relevant to the individual's ability to perform the duties of the position. So a lot of employers make the mistake of conducting interviews in an informal manner. It's a get-to-know-you conversation. It's an informal conversation. It's casual. we're just going to talk about whatever comes up. The challenge is that that opens the door for questions that are improper and that they will elicit information that the employer is not allowed to use in making an employment decision. The stuff that we covered on the first slide of today's presentation. So it's important to think about your interview questions before you conduct an interview, and try and keep the interview as focused as possible on eliciting information that is designed to help you determine whether this applicant is the right person for the job. And it's really easy to fall into the trap of casual conversation, particularly when you want to get to know a person and you want to make a judgment about whether he or she will be a good cultural fit in your organization, whether they're going to get along in the organization. But the challenge is to do those things while asking the right types of questions. So we have a poll here, but on the screen right now is a little quiz, a true or false quiz, 10 simple questions about interviewing. And I'm going to leave it up for just a minute and let you all draw your own conclusions. We'll see the answers on the next slide. And if you will, answer the poll question, and we can get a sense of what everybody's reaction is. Okay, so it appears that overwhelmingly the audience has answered false to the question, which is it acceptable to ask an applicant what clubs or social organizations they belong to? And the answer is, in fact, false. So what's the problem with this question? The answer is this question can result in the employer obtaining information about the employee that has to deal with the employee's religion or national origin, which are off limits. So you want to, later in the presentation, I'll show you a different version of the same question that morphs it into a question that's actually relevant to their ability to perform the job. So another way to ask this question is to ask the applicant what professional organizations they belong to, or what other organizations they belong to that are specifically relevant to their ability to perform the job. So the broad question is, what clubs or social organizations do you belong to? And you are going to get answers like, I belong to this church, I'm on the board of this religiously affiliated organization, and suddenly you have information in your lap that you didn't want and you can't use. And then you have to find a way to make sure that that information doesn't trickle into your decision-making process. So let's move on to the answer slide here. Hopefully everybody's had a minute to take a look at the quiz. And here are our answers. Hopefully no surprises here, but one of the ones that I think, number 3 is one of the ones that I hear with some frequency. If they come and they have a visible disability, can I ask them questions about it? Because, or if they tell, to spin it a different way, if they tell me they have a disability, can I ask them questions about it? And the answer is no. At this stage of the process, you are not permitted to ask questions about an individual's disability, regardless of how obvious the disability may be or whether they bring it up. Asking when did you graduate from college may be a little misleading, because on the one hand, you may be able to figure out how old the applicant is, but the flip side is when you graduated from college is, in most circumstances, directly relevant to their ability to do the job, particularly for jobs that have college education as a job requirement. But of course, you can't ask the individual how old they are or how old their children are, or really anything about their family, because those are not relevant to their ability to do the job. So again, the real task of an interviewer is really not to get to know the person, but to gain as much information about the applicant as you can about whether they will be successful in the position. And that's really the purpose of the interview. There are lots of questions that you cannot ask. Some of them were on the true-false quiz a minute ago. You'll see some more of them in a minute. And we put these slides together specifically to help you navigate the interview so that you know what you can and can't ask. And I've put in real examples for you to work with. But the point is, we got to stay away from questions that are designed to end up with answers that you cannot use. So I'm giving you a couple examples of the types of questions that are common in interviews. These are interviewing techniques that employers are trained to use. So there are closed-end questions, the types of questions that elicit yes or no responses. There are open-ended questions that are designed to elicit narrative responses. I will tell you that a lot of employers prefer to use open-ended questions because it gets the candidate talking, it gets them telling stories, and you can learn a lot more about the person's experience and ability to do the job if you ask open-ended questions. It also makes the dialogue a lot more comfortable. Here is probably the most common type of interview question for professionally trained interviewers, and those are behavioral-based questions. These are questions that are designed to get the applicant talking about something specific in their experience that is translatable to the current job. Tell me about a situation when you went the extra mile to satisfy a customer. If you're hiring a salesperson or a customer service agent, this is a great question. Tell me about a problem that a customer of yours had in the past, and what did you do about it? If you like the answer, then you have a great indicator that this person will be successful in that role for your organization. And it gets them to tell you stories about things that they really have done in their careers that may be transferable to your business. So without dwelling on these too much, here's a quick list of do's and don'ts that are pretty clear. Don't ask what the applicant's maiden name is because their marital status is off limits. Don't ask what their birthplace is because their national origin is off limits. And by the way, it's not relevant to whether they can do the job. The U.S. citizen one is a common mistake. I'm going to show you in a minute what a different way to spin that is also. And obviously it goes without saying based on everything you've heard so far that religious affiliation, what church you belong to, those things are all off the table. I'm going to skim through these quickly. You'll get all of them after the program, but I want to get to the examples of questions so that I can make sure that you all get to see those. Another quick reference list of things that you don't want to ask for. So here's the comparison slides where we talk about specific information that you might be interested in and how to get at it legally and how to get at it in a way that is illegal. So I've given you examples of the wrong way to ask the question and a creative and legal way to ask the question. The first one is a great example. How old are you? What is your birth date? When did you graduate from school? The last one being the exception. The other two, you'll never ask an applicant how old they are. But all you care about is whether they're old enough to lawfully work in the United States, okay? The arrest one is a hot button issue. Have you ever been arrested? Okay, the government agencies take the position that asking people about their arrest record is not probative of whether or not they are able to perform the position. So, and arrests are not indicative of criminal activity because certain types of people are falsely arrested more often than not, and this can create discrimination without intent to discriminate. So, what's the better question? Have you ever been convicted of a crime? Okay, and even then, you should only ask that question if their criminal status is somehow relevant to the job. Okay, are you eligible to work in the United States? That's all you need to know. You don't need to know if they're a U.S. citizen because there are people in this country who are eligible to work here that are not U.S. citizens. All you need to know is whether they're eligible to work in the United States. So there is an alternative way to get at that information. Are you disabled? That's the kind of thing, going back to the wheelchair, that is a no-no. You've got to stay away from that question. What can you ask at this stage of the relationship? Can you perform the essential functions of the job with or without a reasonable accommodation? It's that simple. And it's a yes or a no answer. And that's all you need to know to decide whether the individual is a qualified applicant. Family status, religion is completely off the table. There are just no lawful ways to ask an individual about their religion because it has absolutely nothing to do with whether they're qualified to do the job. It looks like we have a question pending. Okay. The question is, on the last slide, it said not to ask about transportation. What is a good question to ask that gives you insight into if they have reliable transportation to or from work? I think the answer to the question is, here's the schedule. Does that present any issues for you? All you have to know is whether the individual will be there reliably, but you don't have to ask how. And I don't think you should ask how. So you just need to know whether the person can work the hours that are required of the position. That's it. Okay. Hearing no other questions, I'm going to turn it over to Michael Cass to talk about background checks.
Good afternoon, everybody, or good morning. This is Michael Cass. So you've just gone through with Jeremy the, trying to get to the next slide here. Use the wheel. Okay, sorry about that. You've just gone through with Jeremy the interview process, and so now you get to the point where you're going to give an offer to the candidate, and perhaps as part of that offer you may be running a background check, and you're telling them that the offer of employment is contingent upon them passing that background check. And so there are some issues that come up in that context, one of which Jeremy actually alluded to. It's not in the slides here other than the slides that Jeremy already presented, and that is that when you run the background check, you may pick up arrest records, you may pick up criminal conviction records. Arrest records, the EEOC very much frowns upon using those as a basis for denying employment because the statistics are that racial minorities, and particularly African Americans, are far more likely to be arrested. And as a result, if you had a policy that says I don't hire people who have been arrested, then that has an adverse or disproportionate impact on candidates who are black. And so so just having an across-the-board policy on that, and even with convictions, if a conviction came back, to avoid a discrimination complaint, they didn't hire someone who had a conviction. Also, because the criminal justice system, the statistics show, are skewed against minorities as well. For that reason, the EEOC says you need to show basically a business necessity for denying employment based on that conviction. So an easy case would be 3 years ago, and I say this in jest, this person was found guilty of murdering 25 people. Well, there's probably no job that you need to hire him for. I don't know how he'd be out of jail anyway. But if someone 15 years ago was found guilty of a nonviolent crime of some kind, and they're a minority, and they're not being put in a position of controlling the finances of the company or something like that, that might be a case where you shouldn't be using that. And in fact, in some of the states and some jurisdictions, using a criminal record that's older than 7 or 10 years, depending on the state, may actually be unlawful in any event. So when you run the background check, you need to comply with the Fair Credit Reporting Act. And so with the Fair Credit Reporting Act, I think it's always important for employers to understand that this is actually an area of a significant amount of litigation. There are literally thousands of lawsuits filed per year against employers across the country, with the vast majority of these being class action or attempted class actions. And that's a number that continues to actually trend upwards. If you look back over the last several years, even though there's even some relatively good case law that came out this past year that would seem to limit those suits, the trend is still to continue to push them. And you see settlements, depending on the size of the employer, of millions of dollars to shut these down. The key to avoiding the lawsuits in the first place, and then the key to being able to dispose of them easily if you do get sued, is technical compliance with the Fair Credit Reporting Act, which is actually relatively straightforward, but also easy to kind of mess up, so to speak. Oh, I got it. Okay, that's okay. So the Fair Credit Reporting Act requires a couple of important things. Number one is it requires that before you procure an actual, what we call a consumer report for employment purposes, and we're talking about you're going to a third-party agency of some kind, or you're using a third-party source for the information, which in those circumstances, you would need to make sure that you have a clear and conspicuous disclosure that you've given to the employee in writing. And that document has to only consist of the disclosure. It can't have lots of other stuff in it. Can't have anything else in it. The only other thing it could have in it is the employee's authorization, which they would sign off on. Those would be the only two things that can be in that document. That has to be a clear and conspicuous disclosure that we're going to, or we may obtain a consumer report for employment purposes, and you're authorizing us, employee, to do that. You need to have that in writing from the individual. I've put on here a sample of what one federal court held to be a compliant language in a disclosure and authorization form. You'll get these slides later. You know, the disclaimer that we always put on these, and I promise you this is not to drive business to us, but this is the truth. Talk to your lawyer if you've already got an employment lawyer before you would use this stuff to make sure it makes sense for your situation. There's, in addition to a straightforward consumer report, which would be you're basically obtaining a report that has, you know, criminal and credit background information. There are some employers that also do what's called an investigative consumer report, which would mean that you're going to actually conduct interviews of prior employers or references to do more than just confirm what the employee has told you or the applicant has told you, but actually to get, you know, more detailed information about them. There's additional disclosures and authorization that you need to get, and that's what the language is on this slide. So let's talk about a clear and conspicuous disclosure. So the Act doesn't talk about what is clear and conspicuous, but it has to be something that's readily understandable and noticeable to the applicant. It has to be, you know, if it's something, if it's a confusing form, it's not clear. And the key issue is that it has to be solely the disclosure. Other than the authorization, don't include anything else. So the common mistakes that employers make, and these are the vast majority of cases where you see these big settlements or where you see an employer in a difficult situation, is where you have a disclosure form and an authorization form that includes language like, for example, you agreed to release us company, you know, the employer company and anybody else we're talking to from any claims whatsoever related to us looking into your background. That is a common sentence that for years has been on forms, and for good reason. You say, hey, I don't want to be sued because I'm looking into your background. Well, you know what? The Fair Credit Reporting Act actually places requirements on you. So number one, there is an argument under the law that release language is actually unlawful in and of itself, meaning it's against public policy, because how can you say to an employee, you're releasing me for claims, but I have obligations to you, employee, before I look into these things? But the other thing is that is something more than just the disclosure. It's not just a disclosure. I'm now getting a release from that employee, and that now violates the Act. Employment applications sometimes have these disclosures, and then sometimes you'll see employers including other terms of employment. You might have in there, hey, you're also authorizing us to do a drug test. That all has to be separate, cannot be in this form. It's a violation of the Fair Credit Reporting Act. Okay. So many employers use third-party. Many employers use third-party agencies to do these background checks, and it's common just to rely on them to send forms to you, and then you use those forms. So a common issue, though, although it's getting better over the past few years because there's been so much litigation, is that these agencies are actually sending non-compliant forms. Whether it's because they don't invest in legal counsel, whatever the reason is, they're sending non-compliant forms, and then your services contract with that agency often will say you're the one employer who's required to comply with the Fair Credit Reporting Act. And the onus is totally on you, even though you're using their form. So it's very important not to listen to this and think, oh, I'm using background check company's form, it must be fine. You're liable to make sure that that's fine, likely under your contract with that company. Okay, the next area to be careful of, and this is actually probably the most important piece in terms of practically actually potentially causing damage to an employee or an applicant. And that is, if you get negative information, and based on that information, you're going to take an adverse action against that employee, like not hire them or not promote them if that was the circumstance. You have to provide that employee or that applicant notification prior to taking that adverse action. And you have to include in that a copy of the consumer report that you relied on. There's a summary of rights that under the Fair Credit Reporting Act that you have to provide, and then you have to give them a reasonable amount of time to react to the content of that report before taking an adverse action. And the reason for that is to ensure that the employee isn't going to speak up and say, hey, that's a different Joe Smith. I was never convicted of that crime, and to give them a chance to actually correct the record if there's something incorrect. So you allow some time to go by, at least 5 business days, depending on how you communicated that pre-adverse action notice. Maybe longer, depending on how you communicate. If you send it by regular mail, you're going to want to give longer. And then when you're ready to carry out that adverse action, because either the employee didn't react or the applicant didn't react, or they reacted in a way that doesn't change the decision, you then have to give an adverse action notice. And the requirements of that are here on this slide as well. And there are some links down below, and again, you'll get these slides later, the summary of rights to provide and what employers need to know area from the FTC, the federal government. And I would highly recommend, if you're not already familiar with this area of law or this area of compliance, that you take a look at that. So how these claims often happen, as I alluded, is you get a background check, it turns up negative information. You've got procedures in place, maybe even to trigger a pre-adverse action and a post-adverse action notice, but your hiring manager or an HR person, ends up carrying out the action before the pre-adverse action letter is sent out. So you need to make sure that not only do you have sort of the buttons to press, but that the people involved in the hiring process know that you cannot take an adverse action before doing the pre-adverse action process. There are potentially substantial damages if you're, particularly for the larger employers on the phone, if you've got tons and tons of applicants per year and they're getting, for example, non-compliant forms, or you've got folks that you're not using pre-adverse action notices to. It could add up $100 to $1,000 per violation, plus attorney's fees, and then also an exposure to punitive damages. In each state, in some states there are state-specific requirements as well that you'd want to be aware of, but that would be difficult to cover for everybody here now. But certainly there are resources that we could direct you to if you need that. So I'm going to send this on to Jeremy now that we've got through the background check process. And
we do have 2 questions I thought we could go ahead and field. The first of them being, it seems like disability might be relevant towards when considering a job applicant. How is that information not relevant? Can you elaborate a little bit?
Yeah, this is Michael Cash. So the disability itself is technically not relevant. And what Jeremy meant by that is all you need to know is that the individual has the ability to perform the essential functions of the job with or without a reasonable accommodation. So technically, you're correct. If the person comes in and they, and you ask the question, here are the essential functions of the job. Are you able to do that job? And they say, well, I would need such and such an accommodation. So then you would have your normal interactive process to determine if you can provide that accommodation. But saying to an employee or an applicant, do you have a disability, or asking questions to elicit whether they have a disability, other than presenting the essential functions of the job and having them confirm that they can do it, that's where disability is irrelevant. You shouldn't be focused on, do you have a disability? You should be focused on, can you do the job?
And I just like to reiterate, in dealing with disability at the applicant stage, and then also once you get into the employment relationship, it can be tricky. It is a difficult situation to be in addressing those requests for accommodations. And you're going to want to make sure that you are working with your legal counsel, because the pitfalls under the ADA are that if you don't engage in the process correctly, you leave yourself subject to a potential liability as well, where a plaintiff's attorney can come in after the fact because you didn't have those conversations in a way that complied with the law, and second guess what potential accommodations you may or may not have been able to give that employee or that applicant. So I just throw that out there. It isn't an easy thing to address from the employer's perspective, but it is something that you need to consult with your legal counsel about when you're addressing that.
We have an anonymous question asking about a job elimination situation where someone then announced they were pregnant after the decision was made to eliminate the job. That would probably be a better individual question to deal with offline if you wanted to. I don't know if they need to identify themselves confidentially. They can email Alex Hoffman at
ahoffman@equipmentdealer.org, and we'll get you set up with one of the guys or with Natalie to answer your question.
Yeah. And I think with Mr. Stearns as well, I think that your follow-up question would be something that would merit an offline conversation.
I agree. All right, and then with that, we'll go ahead and go ahead and continue. Good questions. Keep them coming.
Okay. This is Jeremy again, everyone, and we still have a lot of content to cover, and we're a little over halfway through the webinar, so I'm going to go through the next section again fairly quickly. You'll get all the content in writing after the presentation, so if you missed something, hopefully you can come back around to it. The point of the next section is, now that you've hired somebody, what do we do to manage their performance? What do we do to avoid the appearance of discrimination in, for example, based on our last question, a termination decision? And so the next section is going to talk about how you document performance issues throughout the employment relationship, if there are any, in a way that ensures that we deal with everybody in a consistent and fair manner. And that really is the most important part of this presentation. I mentioned it earlier, I'm going to harp on it again, consistency. Consistency in documentation is of paramount importance. So this is the consistency of documentation. In fact, documentation at all is great and perhaps the best way to avoid the appearance of impropriety. So what's corrective action? It is anything that is designed to alert an employee that there is some sort of deficiency in his or her performance based on your expectations, and what needs to be done to correct that deficiency. And on the screen right now are several examples of textbook types of corrective action, from the least offensive to the most offensive on a sliding scale. And some employers choose to have what we call a progressive discipline policy, where you start at the least serious and you move to termination. Some employers don't have such a policy, and they want to be able to move fluidly throughout the spectrum, and either way is fine, as long as, again, we treat everybody consistently. The most important thing I can talk to you about today is documentation of your decisions. Okay, I hear this a lot. Why does it matter? Why does it matter if we have formal performance evaluation processes? Why does it matter if we ever write anything down when we have an issue with an employee? We want to handle it casually. We want to have a conversation. The problem is that juries, judges don't believe witnesses as much as they believe documents. Documents don't have the ability to distort the facts if they're done close in time. Obviously, they can be written falsely. I don't want to mislead anybody, of course, but the idea would being that documents are done truthfully and close in time to the actual event. They create a record, and they help witnesses recall facts. Why is documentation more believable than live witness testimony? I don't have to read all of these to you, but let me tell you a couple of the most important ones that I see on a regular basis. The employee who was involved in the situation, the supervisor or the witness, moves on and goes to a competitor and is no longer willing to cooperate with you. Or the employee becomes disgruntled and has an axe to grind, and not to cast aspersions on employees, but decides to fabricate some aspect of the story because they want to get back at you. So if you have documentation that's created close in time, you avoid that issue. And of course, witnesses die, they move, they become unavailable. When you're 4 years out from the actual incident and you're trying to litigate over something, the recollection becomes fuzzy. People don't exactly remember what was said or what was done. A lot of us can't even remember what we said or did a few months ago. And I can tell you that the life cycle of litigation is at least 2 years typically. So you may be asking people to recall specific facts that happened a long time ago. Documentation really helps preserve that institutional memory of whatever transpired. And again, going back to the initial point, the documentation should establish that you treated the individual fairly and consistently. The documentation, I'm going to give you a couple of examples of what I consider bad documentation and good documentation, but the point is you need to try and check some boxes. What are the rules? How does the employee know what the rules are? What transpired? How do we know? What are we doing about it? And how have we dealt with it consistently? Those are the types of things that you want to have in your documentation. Every time you write something down about an employee, and I don't mean day-to-day emails, but on this subject, you should approach that document as if it might be an exhibit shown to a judge or a jury at some point in the future. Get it right. Don't be sloppy. Don't be messy. Make it professional looking to the extent you can, and make sure that it's accurate. Check all the boxes that you can. Document what occurred with the most facts that you can include so that you have a preserved record that you would be comfortable showing to a judge or a jury, knowing that it is correct, knowing that it is truthful, knowing that it is fair, and it is an accurate recitation of what transpired. Number one common mistake in documenting performance issues is that the employer does it too late. Okay, so here's what I see sometimes. An effort to create a paper record where one does not exist, what I would call padding the file. You want to terminate somebody, you've had a lot of problems with them over a long period of time, but nothing's ever been written down. And so now we're worried about whether there is risk involved in the termination decision, and we're going to hurry up and create some documentation very close in time to the termination so that it'll look like we had a long-term performance issue with the employee, but the employee is going to say, they never told me about it, I had no idea there were problems, I didn't know this was an issue, and the documentation is going to look like it's fabricated because it was not created close in time to the event, but rather it was created close in time to the adverse employment action. Make sure that you go over the documentation with the employee. That's another really important mistake that the employers do make. They write something down, they put it in a personnel file, and they never discuss it with the employee. Well, let me tell you, I think it goes without saying that employees can't change things that they're not aware of. So if you don't discuss it with them, if they don't know about it, you cannot have a reasonable expectation that they will have an opportunity to remedy the situation. Keep it job related. We don't want to talk about things that aren't relevant to the job. That's basically the theme of my entire presentation so far. And strive for consistency. Avoid writing documentation in a way that shows that there is a bias towards certain types of employees. Avoid legal conclusions. Okay, here's one I really like. So-and-so sexually harassed their colleague. Okay, whether or not you would continue to employ somebody like that, that's a legal conclusion. Sexual harassment is a legal term, and there are legal definitions for what constitutes sexual harassment. I do not want my clients to document that one of their employees sexually harassed another employee, okay? There are other ways to document it that don't reach the legal conclusion, sexual harassment. So-and-so violated company policy by doing the following. That's a great way to do it without putting a label on it, okay? So I'm going to show you, and here's one example of a file memo based on a performance issue. And here is the names in these examples are all people that work in our firm, or did work in our firm, so I'm at liberty to use them. So here's one. I counseled Tamara today about her insubordinate attitude displayed in a recent meeting. What have we gotten out of that document? Let's just assume it's 2 years after the event and we're looking at this document again. What did we know? Nothing. We don't know who was there. We don't know what she said. We don't know what was done about it. We don't know why she should have known that was wrong. We've learned nothing from this document. It basically doesn't tell us anything. Here's another version that I think is much more appropriate. Here there is detail. This is what transpired. This is who else was in the room. This is what we did about it, okay? Here are specific dates and times, and then, by the way, we showed the document to Tamara at the end of the conversation. she refused to sign it, and instead she wrote her own comments. That's great. I prefer that she sign it, to be honest with you, but I'm okay with her writing her handwritten response on it because that proves that we showed it to her and discussed it with her. We put that in her file, and now we have this level of detail to fall back on if we need to do so in the future. I see we have a question pending, and we're moving through this very quickly. The question is, can I just click? Okay. The question is, can you document an employee that claims to go home sick, but then is in the bar or the mall by 5 or before? Is there any appropriate way to address this issue? Well, I think that the answer is yes. If you have objective proof that the employee has said they were leaving due to illness, but that's not true, then I would address it head on with the employee. And my recommendation would be that you document the proof. Document how the employee communicated to you that he or she was leaving due to illness. Document how you know that wasn't true. And then have a conversation with the employee about it and say, here, look, these are the facts. What do you have to say for yourself? But document it. And there's nothing wrong with an employer having an issue with an employee who fabricates illness so they can go have social time. I would like to go to the bar more frequently than I do, but I have a job to do. And so I think it's perfectly fair for my law firm to expect me to do my job and not tell them I'm sick and then go to the bar. Hopefully that answers the question. Okay, moving right along in our great amount of content. I want to talk to you briefly about how you pay your employees once you onboard them. So let's assume they're doing a good job and we don't have performance issues. What are the laws about how we pay them? Now, I will say this as a threshold issue. Different states in the country have laws, and even some municipalities have laws that supersede what the federal government requires. So you always need to be sure that you are complying with the most restrictive law in your jurisdiction. And there is not enough time on any webinar ever in history to cover all of it. What I want to give you is what the federal law requires, which is the national essential minimum. And if you have state or local laws that exceed what is required under the federal law, please do comply with those. And if you have questions about those, you should ask a lawyer to get into the details with you. The Fair Labor Standards Act is the federal law that was passed in the Depression era that requires employees to be paid a minimum wage and requires employees to be paid overtime compensation for hours worked over 40 in a week. Two very basic concepts of American employment law come from this statute. It was passed in the Depression era, as I said, as a way to get more American workers to work. Instead of employing one person for 60 hours a week, we can employ 2 employees for 30 hours a week. And so there is a disincentive to work one individual longer than 40 hours in a week. That's the underpinning of the law that is still the law in America today. And these are very well-known concepts. Currently, the federal minimum wage is $7.25 per hour. And as I said before, the law requires that employees receive overtime premium pay of time and a half for all hours worked over 40 in a week. I will tell you, again, there are states like California that have a daily overtime requirement that is more aggressive than what the federal law requires. So remember, you've got to comply with those laws too. But in a basic level, this is the law in the country. Let me tell you another thing about the law. The law presumes, I'm going to tell you a little bit about the 2 different types of employees in an organization. The law presumes that every employee in your business is non-exempt. Non-exempt means that they have to be paid overtime and they have to be paid minimum wage. In other words, they are not exempt from the requirements of the law. That is the presumption. There are employees in businesses that are exempt from those requirements. Those are commonly known as exempt employees. Exempt employees do not have to be paid minimum wage, and they do not have to be paid overtime compensation. The great misnomer is that if you pay someone on salary, they're exempt. The other great misnomer is that it's just up to you. It's up to the employer to decide whether you want to pay somebody a salary or whether you want to pay them by the hour. And by the way, there's a status issue with being paid on a salary. There is some connotation in this country that being paid on a salary and not having to ring a time clock means that you are more important to the business. So I hear with some frequency, the employee said they wanted to be paid on a salary, or even worse, the employee said they wanted to be an independent contractor so they didn't have to pay taxes. It's not up to them, and it's not up to you. Everybody has to follow the law, and the point of these slides is to give you the basic understanding of what you need to do to make sure you comply. And I know that we are running long on time. There's just so much content. I'll skim through as much as I can. Here's a slide on overtime pay. Again, over 40 hours in a week, you got to pay them time and a half unless they're exempt. The exemptions are the most important part of this presentation. Please do not fall into the trap of thinking that just because you pay an employee on salary, they can be treated as exempt. The law has specific regulatory requirements that an employee or really a job must meet in order to be paid on salary and not paid overtime compensation and not paid minimum wage. If you don't check one of the exemptions, then you fall back to the default position, which is non-exempt, overtime, minimum wage. Most of the exemptions require that they be paid a predetermined amount of salary. You may have heard last year in 2016, there was a lot of turmoil in the country because the Department of Labor issued new regulations that increased what that salary threshold needed to be. That law did not go into effect. Currently, it's $455 per week. That's the minimum. And then the real subject of debate is the primary job duties. There are a number of slides on what the primary job duties need to be. I won't cover those in detail because time does not permit. The point is that you have to do an analysis of a job to determine if it meets the primary job duties of one of the exemptions. If it does not, they cannot be exempt. It's really, seems very complicated, but it really is that simple.
I'd like to just add in, we did a full webinar on commonly used exemptions under the Fair Labor Standards Act, and that can be found on our website and viewed at any time. So
Great.
If you go to news.equipmentdealer.org, you can find our full webinar on commonly used exemptions.
So this is great. I don't feel as guilty about not being able to cover all those in detail, but there are slides on each of the most common exemptions. Outside sales, for example, is one of the ones that is most commonly misused, where you think that someone in the business who sits in your office and makes calls and goes out to lunch with clients or customers, takes orders over the phone, emails such as that, is considered outside sales. That's not true. There is a slide on the outside sales exemption that will tell you exactly what is required. I do want to touch very quickly on record-keeping requirements, and then I'm going to turn it back over to Michael Cass. The law requires that you keep records about the employees in your business. Here is a list of the things that the law requires. A lot of employers are not doing this. They don't realize this. But by the way, I want to tell you, failing to keep the appropriate records for the appropriate amount of time is in and of itself a violation of the law. And if you are investigated by the Department of Labor, they can issue civil monetary penalties for failing to keep the appropriate records, and they will show up at your office and ask you to produce them. Here is the requirement for time to let you know how much time you need to keep different types of records for the business. There is a question. Can two side-by-side outside salespeople, one be exempt and one be non-exempt? The only difference in job description is exempt and non-exempt. The answer to the question is, if the job meets the requirements of the exemption, it is the employer's option to treat the basic requirements as something that the employer may avail itself of, but doesn't have to. So what does that mean? If you have an employee who is exempt under the law, you can choose to treat their choice as long as you meet the exemption requirements in the first instance.
Oh, they can see.
Sorry. Don't worry about it. We'll be right back.
All right.
Okay. Okay, so we'll talk briefly about protection of confidential information and use of non-compete agreements and similar agreements. So both with respect to the departing employee and the new employee, these concepts are important. This is somewhat basic, but it's important to frame it for you in terms of your own procedures and what you do. There are essentially three levels of agreements that I think every employer needs to consider using. You know, one level, you have a confidentiality agreement that sets forth a definition of confidential information, and the employee is agreeing that as a condition of their employment, they agree not to use or disclose that confidential information outside of the scope of their employment. You have additional restrictions that you could include to make it a non-solicitation agreement, depending on the jurisdiction you're in, the state where you're located or where your employees are located. That would include prohibiting employees, particularly sales employees, from doing business with or soliciting your customers, from soliciting and taking away your employees. And then the more stringent type of agreement, which is enforceable to varying degrees in different states, would be a non-compete agreement, which would include all the above restrictions, but would go further and say you can't work for a competitor within a certain time frame and a certain geography. So, why, would you use a non-solicitation or non-compete agreement? Because in virtually every jurisdiction, if you don't have those agreements, your employees, when they leave you, will be free to compete with you. They'll be free to solicit customers. They'll be free to solicit other employees to join them. Now, there might be limitations on that. If you've got an executive, they might have fiduciary duties, or they might have some kinds of limitations, but they'll be very bare bones. And if you have employees who have access to sensitive confidential information or heavily involved in your customer relationships, and you would be concerned about what would happen if that employee goes to a competitor, if you don't have customer non-solicitation or non-compete agreements, you're very exposed to what that employee could do to you. So the first step in protecting your business in this area is really to talk about actually protecting your confidential information. That's going to be relevant to your ability to enforce non-compete agreements if you have them, but also your ability to protect the information itself. If you want to be able to go to court and say, court, we have a trade secret, this person is using it, we need an injunction to stop them, we need them to give everything back, we need to stop the new company from using this trade secret. Could be a customer list with detailed information. It could be, not likely in the industries that we're talking about, but technical information. It could be business plans and strategies, those types of things. It's important to actually, so a court's going to agree with you that you have something confidential that is protectable under the law. It's really under the Uniform Trade Lawyers to stop someone from using or disclosing that information. It should be and would be valuable to your competitor by virtue of the fact that it's not already known to them, obtainable by other people who could get economic value from using it or disclosing it. And that part about that it's not readily ascertainable, kind of connected to that, is that you have to take reasonable efforts to maintain the secrecy of that information. So if anybody and everybody in your company has no confidentiality obligations, you may be behind the 8 ball very seriously, in fact, in being able to protect that information under any circumstances. So how do we know if something is a trade secret? How do I know if I've got protectable information? The factors would be how widely known is it outside the business? How widely is it known within the company by employees? Is it known by employees who, is it known by everybody, including the janitor, or is it just known by employees who have a need to know? The extent of measures that we take to guard the information. Do we have password access to our computers? Do we have password access to the most sensitive documents? Are file cabinets locked? Do we enter into confidentiality agreements with third parties who see that information? Do I have vendors or customers who see it, but I'm not asking them to maintain the confidentiality? Am I taking measures to guard the secrecy of the information? You can see the rest of the factors there as well. So I always like to say that what a company can do to ask itself if they're taking pretty good measures is, at the minimum, you need to be able to pass the janitor test. And what is the janitor test? Can your janitor learn the information easily and easily disclose it to someone else? So do you have confidentiality policies and agreements? Do you have in your policies, when you talk about confidential information, do you actually have specific language about the most important information, or is it just kind of generally loose information so that an employee might not be on notice as to what's confidential? I mentioned vendors and contractors. Do I have them under confidentiality agreements if they're getting access to my confidential information? Am I actually marking documents confidential that are confidential, so that whomever is looking at or using it within the company is put on notice. This is confidential to the company. Locked file cabinets, password access. I mentioned those things previously. So whether or not you have confidentiality agreements, you also have the prospect of employees who can steal from you. And we live in a high-tech world for many years now, and it only becomes more and more high-tech. Between emails and handheld devices and flash drives and laptops and everything else, it can be easy for an employee to steal. And it doesn't require necessarily an employee coming in the dark of night and taking documents out of a file cabinet the way 25 years ago it might have been. So what should you do to kind of, be able to help prevent employee theft, but also to be able to investigate it effectively if you suspect it? You need solid policies on computer monitoring that puts employees on notice, so that from a privacy perspective, they know these are your computers. You have the right to look at anything and everything they do on the computers. Same with email monitoring. You want to make sure you have the technical ability to lock out an employee from your systems with a snap of a finger, both current and former employees. When an employee leaves, it's important to follow some procedures and some steps to kind of ensure that they're not stealing, and to kind of lock them into a situation where you've got a good legal rights against them if you've got a situation where they are stealing. When someone leaves and you think that they've had any access to confidential information, or you think they're in any way a potential competitive threat, you want to, in an exit interview or a termination letter, preferably an exit interview, remind the employee of obligations, provide them a copy of any agreements they've signed that would have any restrictions in them, require them to return all documents and equipment that they've obtained in the course of their employment. Don't be shy. Get in their face a little bit. I mean, nicely, professionally, but get in their face and don't be shy to say, I need every piece of paper, everything you got in your car, everything you got at home. I need to know that I have everything. Get them to represent that they've done that. Have them sign off on that or confirm that in writing to them afterwards that they represented that they returned everything. You'll obviously want to cut off their computer access. Your sales employee that's controlling $500,000 in annual business, and they say, hey, I'm resigning, and you have any suspicion they're going to the competition, cut them off. That employee is a competitive threat to you at that point. You want to make sure that you're actually complying with your obligations to the employee. If you fail to pay them what's due, whether under commissions, statutes, or laws, or under your agreements, that can kill your ability to enforce a non-compete or other agreement, or to get an injunction against that employee, because you'll also be painted as a bad actor by the employee in any court. If you're giving an employee severance, a common mistake is to kind of let go by the wayside the fact that there's a prior agreement with that employee about confidential information or non-competition. You want to make sure your severance agreements actually reaffirm those prior obligations. When you hire, just like when you're sending an employee on their way or you're bringing an employee on board, you want to do things to protect your information. You also want to make sure that you're not violating the law when you bring on folks from a competitor. You want to know, do they have a non-compete? If they do have a non-compete and you bring them on board, they start taking a bunch of business in particular from your competitor, you could be exposed to a serious tortious interference claim, trade secret misappropriation claims, and those kinds of things. So you minimize your risk by asking at the applicant stage, do they have any contractual restrictions? In an offer letter, if they say no, they confirm the fact that they have no restrictions. If they do have restrictions and you find a workaround so that you're in compliance with them, you work that into the offer letter as well. Of course, if there is a non-compete, I would say two things. Number one, if on its face you go, oh boy, this non-compete prevents the employment. Well, if you're really interested in that employee, go get legal advice. There may be a way around it. But in addition, don't ignore it without getting legal advice. You'll want to make sure you confirm with that employee in the offer letter that they're not going to take any documents from their prior employer. You want to make it clear that you're not part of theft, you're not part of trade secret misappropriation, and you've got that employee representing that they're not going to do those things. So in closing, to protect your business and to protect your trade secrets, use non-disclosure agreements, consider non-solicitation and non-compete agreements to protect yourself. It really depends on the jurisdiction you're in. the culture of your company, your ability to implement those types of agreements. And those are all conversations that a good non-compete lawyer can have with you, and how to navigate that. If you've got non-competes and non-solicits, I would encourage you to really strongly consider enforcing those agreements, or at least putting up a show of some kind of enforcement, so that there's going to be the appropriate deterrent effect for the rest of the workforce. Take those steps to protect your confidential information. Get a legal review of the documents that you do have. If you haven't had someone look at your non-compete in the last several years, or your confidentiality agreements, it's worth getting a review to see, do you have the up-to-date best protection that you can get under the circumstances. And of course, always be careful when you hire from competitors. Are there any questions?
Well, thank you guys so much for your time today. Again, if you have follow-up questions, you can direct those either directly to Jeremy and Mike, or you can funnel those to Alex and I here at EDA, and we will get you connected. Thank you, everyone, for your time. Hope to see you all again at our next webinar.
Thank you.